Welcome to another episode of Nishit Radio. I'm Soumya, and today we have an engaging topic on our hands: the Arkin Cap in third party funding. Joining me are Ansh and Shruti. Together, we'll discuss the evolution, rationale, and application of the Arkin Cap in both the UK and India. Let's begin by understanding what the Arkin Cap entails in the context of third party funding. Ansh, could you provide our listeners with a concise overview of the Arkin Cap and its origins?
Absolutely, Soumya. The Arkin Cap emerged as a safeguard for third-party financiers from adverse costs. In the landmark case of Arkin versus Bouchard Lines in 2005, English courts established that if the funded party is unsuccessful, third-party financiers are liable for adverse costs, but only up to the amount equivalent to the funding which they've already provided, a limit termed as the Arkin Cap.
Thank you, Ansh. Shruti, could you speak to us about the rationale behind introducing the Arkin Cap and the considerations that led to its establishment?
Certainly, Soumya. The rationale behind the Arkin Cap is grounded in the pursuit of justice. The courts reasoned that holding a professional funder liable for the opposing party's costs, but only up to the extent of the funding provided, would better serve justice. This approach prevents defendants from being in a position where they can't recover any costs from funders who had initially supported an unmeritorious claim.
Shruti, did the Arkin Cap face any challenges or modifications over time?
Well, it did. The Arkin Cap faced scrutiny and underwent changes over the years. In Bailey vs. GlaxoSmithKline UK Limited, the English court did not apply the Arkin Cap to an order of imposition of security for costs. In doing so, the court asserted its discretion to exceed the capped amount. The cap also faced dilution in cases like Davy vs. Money and Laser Trust vs. CFL Finance Limited. In Davy vs. Money, the Arkin Cap was disapplied for it being unjust. The court provided an instance where a funder contributes £100,000 to pursue a claim for £10 million on the condition that the funder would take 90% of the net proceeds if the claim succeeded. In such a case, the funder would obviously be made liable for an amount exceeding the £100,000 since his potential gain far exceeded his contribution. In Laser Trust vs. CFL Finance Limited, it was held that where the funder exercises a higher degree of control over the proceedings, costs can be issued against the funder without the Arkin Cap being applicable.
Thank you, Shruti. Now moving to the Indian perspective. Ansh, how does the Arkin Cap or its decline in the UK impact third-party funding in India? Could you also tell us what is the Indian stance on third-party funding in general?
Well, the decline of the Arkin Cap in the UK doesn't directly impact India. Indian courts usually examine the validity of a third-party funding agreement using the standard of extortionate and unconscionable and opposed to public policy. TPF agreements are not expressly barred by any legislature. Certain states have, in fact, impliedly recognized TPF agreements by amending the provision for security of costs under the Civil Procedure Code. That is Order 25. In Uttar Pradesh and Madhya Pradesh, for instance, Order 25 Rule 1 mandates courts to order security for costs if the plaintiff is being financed by another person. In Tamil Nadu and Orissa, the court may order the plaintiff to furnish security if an element of shampooty or maintenance is proved. In Maharashtra and Madhya Pradesh, courts are empowered to order the funder directly to furnish security for costs under Order 25 Rule 3 of the CPC.
Thank you, Ansh. Shruti, could you now elaborate on how Indian courts have handled third-party funding and any noteworthy judicial pronouncements?
Indian courts have allowed third-party funding in certain instances. Notable cases include the Privy Council's recognition in Ram Kumar Kondo vs. Chandar Kanto Mukherjee and the Supreme Court's acknowledgement in Ray Chi, a senior advocate of the Supreme Court. The Bar Council of India rules and the case of Bar Council of India vs. A.K. Balaji acknowledge the validity of third-party funding as long as advocates are not involved. This is because the Bar Council of India rules prohibit an advocate from entering into a fee arrangement which is contingent on the outcome of a dispute, and from buying or agreeing to receive any share or interest in an actionable claim.
Before we wrap this up, can you tell us about any recent development in India in this space?
Recently, the Delhi High Court in Tomorrow Sales Agency versus SBS Holdings refused to order security for the awarded amount against the funder of the award debtor in an arbitration. It differentiated the Arkin case on two grounds. First, the power to order costs against third-party funders was well placed in English statutes which conferred broad discretion to courts in determining who will pay costs. Such legislative provisions were absent in India. Second, in the Arkin case, funders were ordered to pay costs by the courts, whereas Tomorrow Sales concerned an arbitration where the funder was neither a signatory to the arbitration agreement nor a party to the arbitral proceedings. Hence, consent to be bound by the award was an important consideration.
Thank you, Ansh and Shruti, for this discussion on the Arkin Cap in third-party funding. We hope this discussion provides clarity to our listeners.